Josine Johnson and another versus the Attorney General of Trinidad and Tobago.
Mr. Fenton.
My lords, my lady, on every occasion when a territory graduated from colonialism to independence, there was a provision in the Ordering Council for the continuation of existing laws. That was because, with the revocation of previous orders in council, by virtue of which the country was governed, the legal order would have fallen, and the laws would have fallen with that legal order. As a result, the existing laws provision was introduced. We have it in Trinidad and Tobago, and it can be seen at Division 1 of the Volume 1 of the Bundle of Authorities, and I refer particularly to Section 4 of that Ordering Council. Where it says, subject to the provisions of this section, the operation of the existing laws after the commencement of this order shall not be affected by the revocation of the existing order, but the existing laws shall be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with this order.
That's fine, I'm doing well. I'm sorry, Kim. Yes?
At Section 4.5, it will be seen that for the purposes of this section, the expression the existing laws means all acts, ordinances, laws, rules, regulations, orders, and other instruments having the effect of law, made or having effect as if they had been made in pursuance of the existing order, and having effect as part of the law of the colony of Trinidad and Tobago immediately before the commencement of this order. When it was decided that Trinidad and Tobago should withdraw from Her Majesty's dominions and become a republic, the 1976 Act, which is at Division 3 in the bundle, Volume 1 of the Authorities, was passed. The effect of that act was to revoke the 1962 Ordering Council, and Section 5 of that 1976 Act was intended to introduce the new legal order. That legal order was to comprise the existing laws, but they were to be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with this Act. Section 5.1 is now the subject of many opinions expressed since 1962 in cases dealing with a similar provision, the modification of laws provision. And I think it is now accepted that the existing laws are to be construed with the modifications as a matter of requirement. It is not discretionary, it is required that the existing laws be construed with modifications, adaptations, qualifications, and exceptions. As a result of that, we say that the regulations which are the subject of complaint in this appeal would have been inconsistent in the first place, but in the second place, they would have to be modified to excise the reference to females. In the first place, if a law is passed in 1966 or 68, as these two regulations were, and they offended the discrimination provisions of the 1962 Constitution, there would not be laws in force because Section 2 says that any law which is inconsistent is to that extent void. When we look at Section 1 of the 1962 Constitution, which is in Division 1, we see that there are provisions which declare, Section 1, that there have existed and shall continue to exist without discrimination by reason of race, origin, color, religion, or sex, the following human rights. And then we get to the Section 4B, speaks of equality before the law and the protection of the law. And then Section 4D speaks of the right of the individual to equality of treatment from any public authority in the exercise of any functions. So there is, in our submission, a discrimination in these regulations. It is a discrimination which operates adversely against women because they're the only ones who are subject to Regulation 52 and Regulation 58.
Well, of course, Mr. Knox has got an argument that it's not discriminatory. I mean, he's got an argument which you've seen in his case.
Yes.
Is somebody going to deal with that?
Well, they are discriminatory, and the Court of Appeal found that they were.
Yes, but Mr. Knox has advanced an argument to say that it's really just for the avoidance of doubt, to make clear that that it's not going to be an excuse. In other words, it's not going to be an excuse that the woman is engaged in matters relating to the family. It's still, if she's inefficient, that is not an excuse. That's just a clarification. I mean, that's the argument.
Yes, but the argument faces this difficulty, that it applies, the regulations, the two regulations apply to women. If there is inefficiency because of marital obligations, why should that inefficiency lead to termination in the case of women, but not in the case of men?
I don't think there's a suggestion that it wouldn't. I mean, the suggestion is that the system is that if you're inefficient, your employment can be terminated,
yes.
And all that this does is to make it clear that it is not a reason not to terminate an employment on account of inefficiency, that the inefficiency is caused by your concern with domestic affairs. That's the argument, as I understand it, put forward by Mr. Knox.
But the argument that is put forward by Mr. Knox doesn't deal with the substance of the regulation, which is aimed at inefficiency in performance. That's the substance of the regulation. If we look at it, in the police service regulations, this regulation 52, and that is,
in your case.
That is contained in the second volume at Division 9. The Commission may terminate the appointment of a female officer who is married on the grounds that her family obligations are affecting the efficient performance of her duties, and the procedure for the termination of such appointment shall be in accordance with Regulation 51, 2, 3, and 4. So the substance of that regulation is that if family obligations are affecting performance, then a woman can suffer termination of her employment. The complaint is that it doesn't apply to men. And both will have matrimonial obligations.
Yes.
And with the advances in responsibilities for male and female parents, it is quite possible that a male person may become inefficient because of what matrimonial obligations he undertakes. But that regulation would not apply to him. He can only be terminated on some other general regulation. He would not be subject to that one.
Well, I mean, he comes in under 51.1.
Yes.
It's a general provision. Isn't that right?
Yes.
And I mean, the argument, I mean, it's just a way of construing, it's suggested, it's a way of construing the regulation. In other words, that it's there, I mean, this is the argument, that it isn't there to say that you must, that you create a separate ground for termination, but rather to indicate that in that kind of situation, it doesn't provide an excuse for the woman. And nobody suggests, and the suggestion is that it would equally not be an excuse for a man. But they'd had to say it at that time because of the social conditions. It was thought that you should say that. You needed to point it out. It wasn't thought necessary to point it out at that time in the case of men. I mean, that's the argument.
It's a very ingenious argument. Whether it works or not is another matter. I mean, there are several arguments against it, which I propose to put to Mr. Knox. But
just wanted to know what your position was.
I suppose you would say that females under these regulations face the prospect of having their efficiency examined by reference to the discharge of their family obligations, whereas males do not face that prospect.
That is, my Lord, with respect, that is so. Because this is a solitary, well, it's an independent ground of termination. Marital obligations affecting performance. 51.2, where the Commissioner makes a recommendation in writing that the appointment should be terminated on grounds of efficiency, means inefficiency arising in any manner or form.
Absolutely.
Whereas 52 relates only to inefficiency as a result of marital obligations being undertaken. So the two things are different. This 52 was put in there in order to target women.
And there's a difference between inefficiency in 51.1 and affecting the efficient performance in 52.
yes, that was the point I was going to put to Mr. Knox.
And the closing words of 52 suggest that it is a separate ground. There's a separate procedure laid down for it.
Yes,
Well, it's the same.
It's the same
procedure,
procedure.
but it's separately mentioned.
yes.
But the other point is, if we look at the other regulations, which are in tab 8, the police regulations apply the same procedure in regulations 51 and 52, the general regulation and the female police officer regulation. The procedure is the same, but if one looks at the statutory authorities regulations, which are 57 and 58. 57 is the general one, and 58 is the female officer who is married. 58 applies the procedure in Regulation 56, which is different from the procedure in Regulation 57. those were the 2 points I was going to put to Mr. Knox in answer to his otherwise very attractive argument.
Anyway, you're not accepting the olive branch which is being offered by Mr. Knox.
No,
You're not inviting us to approach the
not
matter in
at
that
all.
way.
When this case began, if the government wanted, they could have amended that regulation. They have allowed this complaint to come all the way up before your Lordship's board. It's no use saying that we wouldn't apply it. They have it there as the sword of Damocles over women, and they're not going to amend it. They want to keep that regulation in. And my submission is that the only reason why they want to keep it in is because they want to be able to use it when they feel that it is appropriate for them to do so. If they didn't have it, well, then they will have to come to Regulation 51.1, 51.2, where there would be grounds of efficiency, and that would be, of course, a wider ground than the ground where efficient performance is affected by matrimonial obligations. The same thing would happen in relation to the Statutory Authority Service Commission, where the regulations are similar, but the procedures may be different, as my lady says. Now, '52 speaks of a female police officer, that's police service regulations, and 58, the Statutory Authority Service Commission regulations, speak of a female officer who is married. Now, the Court of Appeal had no difficulty in coming to the conclusion that these regulations were discriminatory, but they said that the regulations were saved by the existing law provision, which brings us back to the case of the Mahasabha, where this Division 14 in Volume 2 of the bundle paragraphs 35 and 36. That was the case where the Order of the Trinity was complained against because it created discrimination as against Hindus
If
and
you just hold
Muslims.
on a second, I think
Paragraph
our
35 and
paragraphs
36.
they've been.
The board had.
No, if you just hold on a second, see whether we've got the paragraphs. I don't think we have, unfortunately.
We are missing pages 12. Our copies are missing pages 12
No, wait a minute.
to
They're
15,
actually
or are
at
they
page.
somewhere else?
They're further back at page. They are for about 2 or 3 pages further back.
Ah. Yes.
They've been just bound up in the wrong order. You've got it.
I think what we've got is 2 copies of pages 9 and 10 and 11. So if we just strike those out, everything will be well.
There's a duplication of page. Got it?
We've got, whatever the
I have
explanation.
9, 10, and 11 twice in this.
Yes, we've
That's
got them
right,
anyway.
yes.
That's fine. Yes.
So what would you like us to look at now we've found them?
Yeah, we are dealing with page 13. Sorry, page 15. Paragraphs 35 and 36.
Yes?
The judge was not asked to consider whether the issue of the letters patent infringed the appellant's rights and freedoms under the 1962 Constitution. If the appellant's argument that this was simply an executive act and not law at all was sound, an examination of that question would of course have been unnecessary. What they failed to do was to appreciate that if they were wrong about this, and it was law within the meaning of Section 3.1 of the Constitution of 1976, the question as to the validity of this act under the 1962 Constitution was still open to argument unless it must be taken to have been validated by Section 18 of the 1976 Act. The existing law clause in the 1976 Constitution could not save a law if that was what this was, which was invalid under the Constitution of 1962. This is not, however, something that their lordships can disregard as they contemplate the situation that the judge's findings of fact have revealed. By Section 2 of the Constitution, it was provided that no law shall abrogate, abridge, or infringe, or authorize the abrogation, abridgment, or infringement of any of the rights or freedoms recognized and declared in Section 1. The effect of that provision is that a law which was at variance with the 1962 Constitution was incapable of being saved as an existing law under the Constitution of 1976 unless it was contained in an enactment within the meaning of Section 18 of the 1976 Act. Existing law is defined in Section 6.3 of the Constitution as a law that had effect as part of the law of Trinidad and Tobago immediately before the commencement of this Constitution. That definition cannot extend to a law within the meaning of Section 3.1, which post-dated the commencement of the 1962 Constitution, was at variance with it at the time when it was made, and is not validated by Section 18 of the 1976 Act. The point I come to, my lords, is this: assuming that these regulations are discriminatory against women, and therefore they fall foul of Section 1 of the 1962 Constitution, because they were made when that Constitution was in force. If they fall foul of Section 1 of that Constitution, well then Section 6 would not have saved them. But at the same time, Section 5 mandates that what did not conform could be modified unless the entire substance was being changed. I think of the death penalty cases where modification was not a sensible exercise. But in this case, modification, simply to excise reference to females, is a modification which it would be easy to adopt. The amendment is going to leave the substance of the two regulations in place, because the termination on grounds of efficiency will remain. And I would have thought that that was the main thrust of the two regulations: termination on the grounds of efficiency. Efficiency which has been affected by marital obligations. So that if we apply Section 5, when the new legal order came into being, we wouldn't have the reference to females anymore. That's my main submission.
What's your submission about Section 18?
Well, Section 18 must apply, but only after Section 5 has done its work. If
That's
Section
on the basis
5...
you concede these regulations are enactments.
I don't concede that they're an enactment, but it is possible for your lordships to give Section 18 a meaning which would embrace them, because of the expression made section 18, because of the expression
But if they weren't enactments, then they would be invalid, if you're right.
if they were enactments,
If they
I
were
wouldn't
not,
mind.
if they were not enactments.
If they were not enactments, they would not be saved.
Exactly.
Yeah. So they would have to be enactments to be saved. But that encompasses this hurdle, that if Section 5 operates before Section 18, they would have been modified before Section 18 could be applied.
But apart from that point,
Yes.
are you driven to accept that they are enactments? Because although they wouldn't be within the normal meaning of the word enactments, the phrase made by any parliament or person or authority
Yes.
suggests that enactments is being used in rather a wide sense.
It does. It does, my lord. But we are not complaining against the entire regulation.
Yes.
We are complaining only against the female part. And then we have to interpret enactment, which is not defined in the Constitution, in a very wide sense to embrace regulations and parts of regulations. And because Section 18 is a restricting provision, it may be difficult to come to the conclusion that these regulations are enactments within 18. The regulations were passed or made by a person or authority. There is, of course, a problem with under or by virtue of the Constitution. Now, we know that the police service regulations are passed under the direct authority of the Constitution, but the Statutory Authority Service Commission regulations are not passed under the direct authority of the Constitution. There's a Statutory Authorities Act, and the Statutory Authorities Service Commission regulations happen to be subsidiary legislation under that Act. So one would have to say that under or by virtue of the Constitution has a reach into the Statutory Authorities Service Commission regulations made by an Act of Parliament, which undoubtedly is passed under the authority of the Constitution.
But if the passing of the regulations, or one shouldn't use the word enactment, but they're bringing into force of the regulations, is ultimately has as source, or its authority, the Constitution. Does that not bring it within Section 18?
Well, that would be the argument, my lord. That would be the argument. But it is not. Section 18 is a restricting provision. It is a provision which, the purpose of which is to derogate from the fundamental rights established by Sections 1 and 2 of the 1962 Constitution. And it would have to be strictly construed, not widely construed. I would have thought that in considering the reach of Section 18, that must be borne in mind, that it is a restricting section. Its purpose is to allow laws which contravened the 1962 Constitution to continue.
It's very odd, isn't it? I mean, I thought it was odd in the earlier case. It's very odd that having got a first constitution, the 62 Constitution,
Yes.
that protects fundamental rights without discrimination,
Yes.
you then have subsequent, I will say legislation, but I know that you don't say that it is, which contravenes that.
Yes.
You then replace it with a new constitution, which is in very, very similar terms and protects those same rights. And at the same time, you say anything that was done under the old constitution is nevertheless valid. It's a very odd thing to do.
The problem about it, my lady, is that sections 5 and 18 do not sit easily together. They do not sit easily together.
What was the effect under the old constitution if a law had one provision which was seriously in conflict with the constitution? It wouldn't be. Would it be that simply the offending provision which would be struck down, or the whole law?
Yes. If suppose the law was passed prior to 1962, the 1962 Constitution in Section 3 attempts to save these laws, but the 1962 Constitution, Section 4, also contains this existing law's provision.
Yes, but I'm talking about a law passed under during the currency of the 1962 Constitution, which contained a provision which was clearly discriminatory. Would it be simply that provision which would be struck down, or the whole law, or would it depend on the relationship of the offending provision with the law as a whole?
No, it would be simply the one that is discriminatory would be targeted by a modification under Section 5.
Again, I'm not talking about Section 5. I'm talking about the situation as it was under the 1962 Constitution.
Well, that part that was contravening, the discriminatory part, that is the part which we could have gone to court and had excised. Section 18 is saying, if you didn't go to court to have it excised, well then it would be treated as having been in force and as an existing law on the appointed day, which means the day the country became a republic.
If Section 18 applies.
Yes. But Section 18, as I submitted, does not sit well with Section 5. And my submission about that is that Section 15, Section 18 would only apply where the law could not be sensibly modified under Section 5. It must be a law which you couldn't tamper with without destroying it. And in this case, we are saying that the regulations can remain. The only parts that we are complaining of is the targeting of females only. And so Section 18 could save the regulation, but it wouldn't save the regulation with the reference to females in it, because that would have been excised under Section 5 of the Act.
I mean, that's really to reopen the fight, the battle, which was fought out in Matthew. I mean, that's what it was all about.
Well, I don't know if I misunderstood Matthew, my lords, but I would like to refer, my lords, to paragraphs 22 and 23 of Matthew.
It's got to be read along with Boyce or whatever the other case is called.
Division 13 in Volume 2, paragraphs 22 and 23.
You've got to start at 20, because that's where Lord Hoffman deals with the Section 5.1 and the consequences of any other view. I mean, they've already been through Boyce. I mean, the same point arose in Boyce.
Well, my lord, Section 22, paragraph 22, the board said, Lord Hoffman said there, on the other hand, a rational scheme results from construing the power of modification, however broad, to be directed to the preservation of those parts of an existing law which are consistent with the Constitution. In such a case, if the form of the legislation is that some part can be retained. The remedy is modification under section 5.1 to remove the part which is offensive. If the whole is offensive, it is invalidated. In either case, it is only the offensive provisions which are struck down, and this is done on the basis of substance rather than form. This purpose appears from the language of section 5.1 even more clearly than it does from the equivalent provision in the Barbados Ordering Council. The opening words are that the operation of the existing laws shall not be affected by the new constitution, but they shall be construed with appropriate modifications. This language shows that the purpose of the section is to preserve those parts of the laws which are not in substance inconsistent with the Constitution, but which, in the absence of a power of modification, might be invalidated because, as a matter of form, they were bound up with provisions to which objection could be made.
But what you're quoting from, Sir Fenton, are Mr. Fitzgerald's arguments. Well, they're definitely rejected.
Paragraph 24, my lady.
Yes, 24.
Mr. Fitzgerald argued that despite the fact that his construction of section 1 would be irrational, that he's talking about the death penalty, contrary to its evident purpose and subversive of the supremacy of the Constitution, it should be adopted to give effect to international obligations and a judicial policy of keeping the Constitution up to date. A similar submission was made by Mr. Starmer in Boyce and the Queen, and their lordships rejected for the same reasons.
I'm afraid I read the whole of paragraphs 21 to 24 as being a recital of Mr. Fitzgerald's arguments, ending in the sentence saying that we reject it, as that argument has already been rejected in paragraph 20.
I think the whole purpose of these paragraphs was to show that there could be laws where parts are offensive and parts that are not, and the offensive parts could be removed. But the whole idea was to keep the laws going.
I must say, I do doubt whether section 22 is meant to be Mr. Fitzgerald's argument. Section 21 begins the irrational consequences, and then 22, on the other hand, a rational scheme.
I think that's right.
Yeah.
I have to say, I do find paragraph 22 not as clear as one would expect.
Well, the difficulty is to read that along with paragraph 20.
Yeah. The basic message, as I recall it, was that you could not use something outside the Constitution. I mean, that was to modify what was in the Constitution, and that was my understanding. And all that, my recollection at any rate, was that what could be done was to modify things which were simply matters of form. For example, where statutes referred to the Queen or something like that, then one read them with the necessary modification. Now it would be the President or whatever it was. I mean, that was, as I understand it, the message which the board was putting through.
Oh, but we've gone, in the last 47 years, we have gone far past that law.
Yes, but I mean, you know, it was to allow what was just matter of form in the first Constitution and in the acts passed under the first Constitution, dealing with the situation as it then was. Then one used this section in order to make to read them in a formal way, so that one just interpreted them in the light of the new situation. But that was as I understand it, was what the way one was meant to reconcile what was meant by Section 5.
Yes, but my lord, what has happened is, assuming that formal modifications were meant in 1962, when Jamaica and Trinidad got their independence, subsequent decisions, including decisions of the board, have said that the word construe has a much wider connotation and it could lead to amendments. That is clear from the decisions in Mollison, where this board, can I refer to Mollison, my lords?
Before you go there, is it possible to look at Boyce for a moment? I think paragraph 49 of Boyce, I think, is the explanation of what the majority had in mind in Matthews.
Yeah. Voice, paragraph 49.
I think it's the previous tab. Page 658 of the bundle.
The argument, as I understand it, is that the power in Section 4.1 and in 5 or whatever it is under the Trinidad is designed to deal with formal things like references to the Queen or to the Governor-General, whatever it may be. You don't say because of that the particular provision is no longer valid. You read that out because these are just formal things, the substance of the law being unobjectionable. But what Lord Hoffman goes on to say in section 50 and so on, is that, in paragraph 50 and so on, is that if the effect of the existing laws clause is that the law is to be held to be valid and unchallengeable, then there is no room for the use of section 4.1 or section 5. Because the Constitution has declared that those are valid. And so you don't get into the question of using the section 5 or section 4 in the Barbados Constitution. Because the Constitution says that they're valid. And that's the way in which the board construed these provisions.
All right. Well, my Lord, let us look at it this way then. When these regulations were passed in 66 and 68, there would have been...
They might have been open to challenge, but they were not challenged.
Yes.
And so we come to section 18, and this is the argument.
But if they were not challenged, there would still have been bad regulations. There would still have been bad regulations. So section 18 intends to say that if they were not challenged, well, then they will now be good.
Yes. That's what they did. They said you can't. I mean, that's what section 18, it's not found in some of the other constitutions and so on, but that's the way. It wasn't available in the Forrester Bow case, for example. Because there, what was done in that situation was to say retrospectively what the position would have been under whatever I can't remember which country it is concerned, but whatever was the first constitution of that country. And the board said, well, if the matter had been considered, then the result ought to have been to find the thing invalid, and therefore it wasn't saved by the subsequent constitution. But that was because it didn't have a provision that we find in section 18, which says validates the law unless it has been set aside, whatever it says, declared by a competent court to be void. Now, there isn't. That's the difference between this and Forester Bow, as I understand it.
Can I take the board to Mollison and then to a case which Rojas. It's in Division 11. Now, this was a case in which the board had to consider modifying a law which allowed detention at the Governor General's pleasure. And the modification was to the effect that the detention would be at the court's pleasure. But there are certain observations that were made in this case by the board. At paragraph 7, it is said that on August 6, 1962, Jamaica became an independent state within the Commonwealth upon the coming into force of the Constitution scheduled to the Jamaica Constitution Ordering Council. Jamaica thereupon became subject to a new legal order. Section 2 of the Constitution summarizes its effect. Subject to the provisions of Section 49 and 50 of this Constitution, if any other law is inconsistent with this Constitution shall prevail, and the other law shall, to the extent of the inconsistency, be void. Thus, subject to its terms, the Constitution was to be the supreme law of Jamaica. Section 49 lays down long and detailed conditions for the amendment of the Constitution. Section 50 lays down conditions, no less exacting conditions, for the amendment of sections 13 to 26 inclusive of the Constitution, being the sections which make up Chapter 3. Chapter 3, my lords, is the section on fundamental rights. At paragraph 10, reference is made to Section 4 of the Jamaica Constitution Ordering Council. It provides all laws which are in force in Jamaica immediately before the appointed day shall continue, but shall, subject to the provisions of this section, be construed in relation to any period on or after the appointed day, with such adaptations and modifications as may be necessary to bring them into conformity with the provisions of this order. There follows a series of subsections providing that references to old office holders and institutions shall be understood as references to the new office holders and institutions. And then in subsection 5A, a general, although time-limited power is conferred on the Governor General. That is the power of the Governor General to modify laws within 2 years. It seems clear that Section 4 had two complementary objects: to ensure that existing laws did not cease to have force on the coming into effect of the new legal order, and to provide a means by which existing laws could be modified or adapted to ensure their conformity with the Constitution and preclude successful challenge on grounds of constitutional incompatibility. Then he deals with the question of the separation of powers. In section 14, paragraph 14, sorry, it says the director contended in reliance on section 26(8) of the Constitution that since section 29 was a law in force immediately before independence, it could not be held to be inconsistent with any of the provisions of chapter 3 of the Constitution, including sections 15(1)(b) and 20. The validity of section 29 could not therefore be impugned, even though it was inconsistent with those subsections. Subject to the argument considered in paragraphs 18 to 19 below, that submission is plainly correct and explains the respondent's reliance on the general separation of powers challenge considered above. Since the respondent's challenge did not depend primarily on incompatibility with any of the provisions of chapter 3, section 26(8) could not be relied on by the director to defeat it. Instead, he relied on section 4(1) of the Jamaica Constitution Order in Council and on a passage of the board's judgment in Hines and the Queen, where Lord Diplock said, section 29 of the Juveniles Law and section 49 of the Criminal Justice Administration Law are of no assistance to the respondent's argument. They were passed before the law-making powers exercisable by members of the legislature of Jamaica by an ordinary majority of votes were subject to the restrictions imposed upon them by the Constitution. Though they were subject to other restrictions imposed by the Colonial Laws Validity Act 1865. The validity of these two laws is preserved by section 4 of the Jamaica Constitution Order in Council. No law in force immediately before the 6th of August 1962 can be held to be inconsistent with the Constitution. And under section 26(8) of the Constitution, nothing done in execution of a sentence authorized by such a law can be held to be inconsistent with any of the provisions of chapter 3 of the Constitution. The constitutional restrictions upon the exercise of the legislative powers apply only to new laws made by Parliament established under chapter 5 of the Constitution. They are not retrospective. Then the board says, the board finds this a puzzling passage, and it goes on to say that because of the separation of powers doctrine, they could declare that a person can be detained during the court's pleasure rather than during the Governor General's or during Her Majesty's pleasure. And the board referred to cases where modification has taken place. And 5 authorities called for brief mention. Kanda and the government.
Sorry, where are you reading from?
Then some others there.
Oh, down at the bottom paragraph. What point is it you're making?
Paragraph 16. Paragraph 17. Paragraph 17 comprises a reference to the authorities where modification took place. And in paragraph 17, this is what a reference was made to what the Court of Appeal had said in a case of Rudal. It's on page 427, where Chief Justice de la Bastide reviewed the authorities, giving a summary which fully merits quotation. Having made this review of the authorities, we are now in a position to assess the purport and effect of Section 5(1) of the 1976 Act. The first thing we can say about that section is that though it speaks of existing laws being construed, the type of construing which is involved is not the examination of the language of existing laws for the purpose of abstracting from it their true meaning and intent, nor is it attributing to existing laws a meaning which, though not their primary or natural meaning, is one that they are capable of bearing. In fact, the function which the court is mandated to carry out in relation to existing laws under this section goes far beyond what is normally meant by construing. It may involve the substantial amendment of laws, either by deleting parts of them or making additions to them or substituting new provisions for old. It may extend even to the repeal of some of the provisions in a statute or a rule of common law. Mr. Daly's submission that the section should be regarded as conferring very limited powers is, I am afraid, a brave but unavailing attempt to turn the clock back. In the light of this authority, the board concludes, in agreement with the majority of the Court of Appeal of Jamaica.
I mean, this was all what came up. I mean, this is what was considered when Rudall came on appeal, and then when Rudall was then reconsidered in these subsequent cases. I mean, that's what this was all about. I mean, that authority was in play in these cases. And we have in the considered opinion of the board, the majority of the board, in Matthew and in the Barbados case, we've got what is the position on that matter. I mean, that's what that was all about. It was exactly to consider what the scope of Section 5.1 was. That was what it was all about. And the board rejected the kind of approach which we see was taken by Chief Justice de la Bastide. That was the whole point of the case.
Lords, if we look at if the question is, my lords, the extent to which modification is allowed, rather than mere formal modification to replace a Governor General with President and things like that, but going into substance, then we could see that there has been modification of substance which the board has approved.
The position taken by the board in Matthew and in the Barbados case was that where a law is covered by the existing law provision and is validated by that, where that is the case, there's nothing to modify. There's no basis for modifying because it is consistent with the Constitution. I mean, that was what was held. And the argument was rejected that Section 5 was there to modify things and bring them into the line with the Constitution in the case of existing laws. That was the whole point. The argument was, in the end of the day, the view accepted by the board was that where the Constitution validates an existing law, there is no basis for saying that that law is inconsistent with the Constitution. Therefore, there's nothing to modify, except insofar as it uses languages like references to the Queen and so on and so forth, which are simply formally matters of form and not of substance. I mean, that was the battle which was hard fought in those cases.
In Matthew, at paragraph 21, the majority say the board accepts that the power of modification conferred by section 5.1 is extremely wide. See the passage from the judgment of Chief Justice de la Bastide in Rudall's case, quoted in paragraph 23, presumably of Boyce, although it isn't there, I think.
You've got to read that in line with 22. Yes. On the other hand, a rational scheme results from construing the power of modification, however broad, to be directed to the preservation of those parts of the existing law which are consistent with the Constitution.
I refer my lords now to the case of Rojas from Gibraltar. Some extra copies have been made for the benefit of your lordships. I wish to refer to paragraph 24. This was a case in which it was compulsory for men to serve on juries, but for women, there had to be a voluntary submission to go onto the list. And there was a complaint that as a result of that discrimination, the list was not jury list was not representative of the community. And at paragraph 24, the majority judgment given by Lord Nichols reads thus: Their Lordships are unable to accept these submissions. Paragraph 2 of the transitional provisions imposes a far-reaching obligation on courts. As noted in the Director of Public Prosecutions of Jamaica and Mollison, this type of obligation goes beyond the limits of construction of statutes as usually understood. In the usual course, the process of construction involves interpreting a provision in a manner which will give effect to the intention the court reasonably imputes to the legislature in respect of the language used. The exercise required by these transitional provisions is different. The court is enjoined without any qualification to construe the offending legislation with whatever modifications are necessary to bring it into conformity with the Constitution. There may, of course, be cases where an offending law does not lend itself to a sensible interpretation which would conform to the relevant Constitution. That is not this case. The offending provision here is the provision according to women a different liability to jury service than men. The modifications to section 19 most naturally to be made when construing this section is a constitutionally consistent manner. In a constitutionally consistent manner, those identified by the Chief Justice. Section 19.1 is to apply to women as well as men, and section 19.2 is to be omitted. Section 19 should be read accordingly. Far from this being an unworkable result, in reaching this conclusion, the Chief Justice had in mind the practical inconveniences which would flow from adopting the alternative course of merely granting a declaration of unconstitutionality. That is a matter on which the Chief Justice is much better placed than the board. I'm obliged.
Thank you, sir. Mr. Newman?
Excuse me,
Sorry.
the lectern moves to you. You stay where you
No,
are.
I think we'll just leave it as it is.
Yeah.
They were happy to. I think there's, and this has been put in here. Yes,
My lords and my lady. May I begin by simply, because I think it will assist, correcting one or two errors in the index. Because I think I'm sorry to start with such a lowly matter, but item 2 in the index wrongly reads at the moment 1962 Trinidad and Tobago Constitution. It should read 1962 Trinidad and Tobago Independence Act. That's item 2. And item 1, perhaps you, my lords and my lady, might wish to note that the 1962 Constitution is contained at Schedule 2 to this Order in Council. Now, my starting point must be to persuade your lordships and my lady that the provisions are discriminatory. If they're not, then the appeal falls in limine. I'm not going to repeat the matters that have already been adumbrated in the course of discussion, although I obviously adopt what the defendant says.
And you've got the Court of Appeal with you on that matter.
Yes, well, the first point I'd like to make, I'm not making this point in order to ban my learned friend from making whatever points he wants. But can I take, my lords and my lady, to the record of proceedings and invite the court to look at page 75, which is the Court of Appeal judgment. Well, it begins at page 75 of the record. And the actual judgment or decision is briefly stated in pages 76 and 77. And can I firstly invite the board to look at the very end of the Court of Appeal judgment, the last two lines, page 77. To point out, as is clear from the last two lines of the judgment, that in the Court of Appeal, the state conceded that the regulations were discriminatory. As I say, I'm not seeking to advance this in order to prevent my learned friend from advancing whatever he wants. But the fact of the matter is, it's my submission, they were quite right to concede that the provisions were discriminatory for the reasons already identified and one or two others that I'm going to turn to in a minute. And also, paragraph 4 of that judgment, the opening line, refers to the fact that there was the state effectively accepted that the regulations were discriminatory. So that's the background. My learned friend Mr. Knox now seeks to resile from that. Can I invite the board to look at, either provision will do, but to look at flag 8 at the Statutory Authorities Service Commission regulations at Regulation 58 on page 469. It is clear in my submission that paragraph 50, or section Regulation 58 adds to Regulation 57 for the reasons in part identified by my Lord Collins, that there is a difference between terminating on grounds of inefficiency and terminating on the basis that the married person's obligations are affecting efficient performance. It's a much looser test. Not only that, but it's obvious on the face of it, from the wording, that the provision discriminates against women, because it only refers to females, but it also has other forms of discrimination. It discriminates against married women in favour of, for example, women who are in a common law relationship or who are single parents. So, learned friend may resile, but I invite the board to the conclusion that it's self-evidently discriminatory on ex facie, if I can put it that way. Now, we are not concerned in this case with regulations which predated the 1962 Constitution. When we are considering existing law provisions, we're dealing with the provisions relating to existing law as regards the 1976 Constitution, looking back to about 1968 or 1969, which is when I think these regulations came into effect. And it's clearly, in my submission, important to identify the relationship between Section 5 of the 1976 Act and Section 18 of the 1976 Act. May I invite the following argument? It's a flag 3, the 1976 Act. Can I first invite the board to look at Section 18 on page 109? Can I make this simple observation for your lordships and my ladies' consideration, which is this. Section 18 looks backwards in time, Section 5 looks forward in time. So when we come to Section 18, it looks to see whether or not a particular provision may or may not have been inconsistent with sections 1 and 2 of the 1962 Constitution. It doesn't, section 18 in itself does not deal with the 1976 Constitution. Of course, it has relevance to it. I'm not disputing that. But it's looking to see whether a particular provision breaches or does not breach, or is inconsistent with sections 1 and 2 of the former Constitution. Section 5...
Have you left section 8?
Well, Lord, your Lordship has a...
I just want to be sure that your side concedes that these were enactments within...
Well, Lord, Sir Fenton has made one or two arguments to the effect that they weren't. I don't intend to add to that. And I don't intend to add... Sir Fenton has not conceded the point. I'm not going to adopt a contrary stance, but I'm not going to advance any submissions at all that they're not enactments. So, for the purposes of argument, without making a formal concession, I assume that the board comes to the conclusion that they were enactments, unlike, for example, in the Trinity Cross the Saba case, where the board came to the conclusion that an exercise of prerogative power did not amount to an enactment. But this is a different situation, obviously. So I'm not advancing any argument to the fact that they're not enactments, but without conceding the point formally, if I can put it that way. I'm sorry, I don't know whether that's helpful, my lord, but that is my position. Section 5, which is at page 103, can I point out the mandatory word shall in the fourth line? It's not really a question of discretion. The court is, whichever the court is, the board in this case, is obliged to construe existing laws with such modifications, adaptations, qualifications and exceptions as may be necessary to bring them into conformity with this Act. Now, my Lord, Lord Roger, seeks to put a very narrow interpretation, if I can put it that way, on
I just try to apply what I understood the board to have decided after a considerable amount of argument.
Lord, in my respectful submission, the breadth or the narrowness of Section 5 was not a matter which was specifically necessary for the decision in Matthew.
It was absolutely central.
And Lord, may I invite my Lord and the board. I mean, the wording of Section 5.1 does not necessarily require a narrow interpretation. The wording is in general terms, and the
question was, what did it apply to? I mean, the argument which caused the difficulty for those who were seeking to challenge the existing law was, this is a broad power, but they had to find some purpose to the provision, as in section 18, preserving existing laws. And so it came to what Lord Hoffman regarded as a really very strange argument. And that was, the one thing you couldn't do was to invalidate, modify a whole law, and therefore the worse the infringement of human rights. When you had a law which infringed human rights completely, it was valid, but anything which only infringed it a bit, because you could score bits out, that was all right. Now he thought, and the majority on the board thought, that was an irrational view to take.
Lord, I know that your Lordship, I think, was one of those
yes,
in the minority who took a...
I was a majority in that.
your Lordship was a majority in that. Right?
Yes.
So your Lordship was in a minority in Rockhouse, I'm so sorry.
Absolutely.
Yes.
Rudolph.
Lord, certainly the minority, and I appreciate it was just about a minority of 4 out of 9, if I can put it that way, the minority took a different view.
Yes, absolutely.
And whilst it's not the view of the majority, I would respectfully submit that to paint it as an irrational stance.
But that was the way, all I'm saying, that is the way that Lord Hoffman put the argument which was advanced. That was the problem about the argument.
Right. Well, my Lord, so far as there is a difference in this sense. Here we are dealing with the validity or otherwise of secondary legislation, namely the regulations. In Matthews, the board was dealing with the validity of effectively a sort of common law principle which had existed for a long time, relating to the mandatory death penalty, which either was good or bad. There's no question of any severance or anything like that so far as the mandatory death penalty is concerned, nor was there any, and indeed...
Mr. Newman, the whole point was that in Ray's and all these other cases, the board had read down mandatory provisions to make them discretionary. That was what was being argued.
No, it is.
So, and what was held...
But it was rejected.
What was rejected in Matthew was exactly that argument.
No, but Lord, supposing the difference is this, that if in this particular case, whichever of the two regulations one looks at, it is easy to excise, if it's possible to do so, it is easy to excise the offending provision and leave all the other provisions outstanding. In the case of Matthew, that possibility wasn't really there. I appreciate that there may have been an argument to read it down as a discretionary as opposed to a mandatory requirement. But that is effectively, as the board held, the majority of the board held, would amount to the board legislating effectively, and that was not considered to be...
May I ask what may turn out to be a very stupid question?
Certainly.
Assuming that Section 5.1 has a narrow scope, what is it that prevents Section 5.1 of the Constitution itself from applying to laws which have been saved under Section 18?
Nothing at all. The wording is... May I just have it?
And I couldn't find any provisions about the laws passed after the appointed day and so on.
No, Lord. Yes, Section 5.1, in my respectful submission, I hadn't... that particular point had not occurred to me, but looking at, taking my Lord's point, there is nothing to prevent that applying at all. I mean, the wording of Section 5.1 of the Constitution, it doesn't look either forward or backward. It's a general provision. No law may abrogate, abridge, etc.
Has this point arisen in any of the other cases?
Lord, I don't think so. I hesitate to say so, but I don't, not that I'm aware of, Lord, no.
What?
That even if one, so to speak, disregards for the moment Section 5.1 of the Act, the question that my Lord was asking me was, what about Section 5.1 of the Constitution?
But isn't this really what came up in the other discrimination case, the Trinity Cross case? Because one has Section 5.1 of the Constitution that says no law may abrogate, abridge, or infringe, or authorise the abrogation, infringement, etc., of the rights and freedoms herein before recognised and declared. You then have Section 6 of the Constitution,
Yes.
which says nothing in Sections 4 and 5 shall invalidate an existing law.
Yeah.
Existing law means a law that had effect as part of the law of TNT immediately before the commencement of this Constitution.
Well, that's it.
Now, Section 18, therefore, is the one that answers the conundrum that occurred to us in the Trinity Cross case, which is that you have laws passed after the 62 Constitution which are inconsistent with it and are therefore ex facie invalid under the 62 Constitution and therefore couldn't count as existing law for the purposes of Section 6 of the 1976 Constitution, were it not for Section 18.
It was a stupid question.
Well,
No, it's not a stupid question.
Lord, yes, and my lady, I respectfully accept that that is the answer to my Lord's question, in fact, and I accept that. Lord, without inviting the board to adopt a broad interpretation of Section 5 of the Act, which my Lord says was effectively examined in any event in the case of Matthew.
It was given a broad interpretation, but a narrow scope. The power is broad, but the scope in which it can be applied, within which it can be applied, is narrow.
Well, may I respectfully invite the board to consider this as part of the scope that it has? I don't imagine that the board will find any difficulty with the proposition that statutory provisions must be construed so wherever possible so as to be in conformity with international obligations. And if we look at, I do this very shortly indeed, may I invite the board to look at flag 5, Trinidad and Tobago ratified this convention, the date is in the papers, I think it's 1990 that it ratified the convention. And can I just invite the board to look at, I mean, there are many articles where we would say that are relevant. Article 1, Article 2A, 2C. I'm making the respectful suggestion that the offending provisions in the regulations, let's say regulations 52 and 58 respectively, are clearly not in accord with the Convention for the Elimination of All Forms of Discrimination Against Women. So we've got Article 1, Article 2A and 2C, Article 7C, and perhaps 7C is particularly apposite, given the fact that both of these appellants are employed in public services of one sort or another, police and health. And so 7C requires the states to take all appropriate measures to eliminate discrimination, and we go to C, to participate in non-governmental organisations and associations concerned with the public and political life of the country. Article 11, 11.1b, states parties shall take all appropriate measures to eliminate discrimination against women in the field of employment, and then we get to B, the right to the same employment opportunities, including the application of the same criteria for selection in matters of employment. Article 11.1f may be applicable in the context of the particular provisions which are in question. So even if the board in Matthews decided that the scope of section 5.1 is a very narrow scope, in my respectful submission, however narrow it is, it's broad enough, or your lordships and my lady should hold that it is broad enough to permit an interpretation, if possible, which gives effect to construing the provisions so as to be in conformity with international obligations.
I mean, nobody's doubting you can do your best to construe the provision, the regulations and so on.
No, the provision in question that I have in mind is section 5.
That was argued. That, of course, was argued in Matthew and in whatever the Barbados case is called. I mean, that was, all these points were put. I mean, they weren't in voice. They weren't forgotten.
Well, Lord, I can do no more than invite the board to avoid the austerity of tabulated legalism, if I know what it means, basically, in interpreting Section 5. I'm not...
The context of Section 5, subsection 1, is the catering of the consequences of the revocation of the Order in Council of 1962. Is that right?
I'm so sorry, my Lord. Would you...
Yes, Section 5, subsection 1.
Yes.
Well, perhaps I should put it as an interrogatory rather than a proposition. Do you accept that the context is to cater for the consequences of the revocation of the Order in Council of 1962?
Yes, of course. I do.
And when one identifies that as a context, does that inform the debate as to whether this is a provision which allows amendments of substance rather than amendments of form?
Lord, I would respectfully submit no. There's no, apart from, unless the board has specifically stated, so to speak, that it should be interpreted in some narrow way. No, Lord, is my answer to your Lordship's question. There's nothing in the wording which... indeed, the wording, if one looks at the wording, modifications, adaptations, qualifications and exceptions, that provides an enormous discretionary power. And my Lord Roger is not indicating the contrary. I appreciate that.
But the rule that statutes have to be interpreted in accordance with international obligations couldn't have any effect on Section 5. It could have an application when, for example, a policewoman is dismissed for grounds which she says fall short of what would be regarded as inefficiency by in a policeman, and then it might be said, well, one should construe the provisions relating to policemen and policewomen in the same way so as to conform with the convention.
Well, I certainly accept that, of course, the regulations it's possible to construe the regulations in a way where they should be construed in a way so as to be consistent with international obligations. But I respectfully invite my Lord Collins to take a somewhat broader approach to there is no reason why Section 5 of the 1976 Act isn't, the interpretation of that provision isn't also amenable to that principle.
Yeah. Also, would Section 14(1) of the Constitution give if the regulations were actually applied in a discriminatory way, would there be a remedy under Section 14(1) of the Constitution?
That's what this is. I mean, this case is brought under...
Yes, but it may be that the case can't be brought under Section 14(1) as regards validity because of the combined effect of Sections 18 and 6. But it wouldn't, would it, even if the question of validity couldn't be raised, could the question of application in a discriminatory way be raised under Section 14?
I would imagine that Section 14 can always raise
So there would be a remedy?
Well, there would be a remedy after the event, if I can put it that way. But yes, no, yes, the remedy, I'm reminded that the wrongful application of the regulation would clearly offend Section 4D of the Constitution, which is to be found, well, Section 4D, the right of the individual to equality of treatment from any public authority in the exercise of any function.
Even if it's authorised by something which is presumptively, on this basis, assumed to be a valid law?
Yes, if you apply you can apply a valid law in a way which is contrary to the Constitution. I mean, powers of arrest may be given. It doesn't mean to say that you can't arrest somebody in a way which offends the provisions relating to...
Yes, but if, for example, the death penalty were authorised, you couldn't say that the application of the Act was...
If the proposal was to kill somebody in a particularly cruel way, I don't know about that, my Lord. I would respectfully submit that it could be challenged.
That would have been an answer to the death penalty cases.
Well, it wouldn't if I can put it this way, ordinary hanging, I'm sorry to use this expression, but if ordinary hanging is authorised, but some much crueler way is suggested,
Oh, yes.
that would give rise to in my respective submission, to the ability to take out a constitutional motion contrary to section 14. There is, in this case, affidavit evidence from both of the applicants as to why they are concerned to take this provision now, to challenge this provision now. And Lord, without reading it out in full, can I just invite my lords to note that the appellant Johnson has an affidavit at page 8 of the record, and the appellant Balwant has an affidavit at page 11 of the record. Clearly they have, I don't know whether my learned friend is really maintaining that they don't have a sort of locus at the moment to take this point, but if he is, then my respectful answer is to be found in the affidavits in this case.
But the affidavits are in virtually identical terms. They don't give a strong impression of coming from the heart of the two ladies in question.
Well, whether they come
They
from
are
the heart
in
or not,
identical terms.
yeah, but so they would be. They're both in a stable relationships and are concerned about the effect if they marry on their promotion rights. They're in identical terms because the legislation is in identical terms. It's obviously been, if by that, if my lord means they've been settled by a lawyer, I don't know, but I'm quite sure that may be the case. But unless my lord is saying somehow that they are not to be believed or whatever, then I answer in the most polite way possible, so what? That they are in identical terms.
But the point is, whether or not, forget the affidavits, if somebody believes that it will be to their disadvantage to marry, which would not be an irrational belief, unless Mr. Knox is right about what the regulations mean, well, then they have already suffered detriment, because marriage is, on the whole, to people's advantage,
Which is
rather
why
than disadvantage.
My lady, which is why I began by saying that the discrimination in these provisions is not just men versus women, it's married women versus unmarried women.
That's right.
And the whole, if you want, the institution of marriage is discouraged, if I can put it that way, by these provisions. Lord, your lordships were referred to the case of Rojas, the Gibraltar case. And although Rojas was decided before Matthews, in my respectful submission, what Rojas says about the breadth of or the powers under Section 5 are still of relevance. I'm not sure that my Lord or others quite. Paragraph 22, if I can start there. Present case stands apart from Hutchison and Davis. In the present case, unlike Davis, offending law is an existing law. Accordingly, in compliance with the Constitution's transitional provisions, courts are required to interpret existing laws in a manner comfortable with the Constitution. The existing laws, and then there's emphasis on the word shall be construed with such modifications, etc., as may be necessary to bring them into conformity with the constitutions. And then reference is made to Reyes and Hughes. And Lord, whatever, in Matthews, Reyes was upheld. Rudal was not followed, but Reyes was not challenged, if I can put it that way, by the board in Matthews. Then they, in paragraph 23, your lordships set out submissions made by the Attorney General, and that's dealt with in paragraph 24, if I can turn to that. Their lordships are unable to accept these submissions. Paragraph 2 of the transitional provisions imposes a far-reaching obligation on courts. As noted in Mollison, this type of obligation goes beyond the limits of construction statutes as usually understood. In the usual course, the process of construction involves interpreting a provision in a manner which will give effect to the intention the court reasonably imputes to the legislature in respect of the language used. The exercise required by these transitional provisions is different. The court is enjoined, without any qualification, to construe the offending legislation with whatever modifications are necessary to bring it into conformity with the Constitution. I would add the words interpolate, if I may, where it is possible to do so. Clearly in Matthews it wasn't possible to do so. There may, of course, be cases where an offending law does not lend itself to a sensible interpretation which would conform to the relevant constitution. That is not this case. In fact, the offending provisions in the Rojas case are much closer to the situation that the board is faced with in this case than Matthews, because it was a sex discrimination case, effectively. The offending provision here is the provision according women a different liability to jury service than men.
I mean, there was no existing laws clause which made them, validated them. I mean, they were to take effect, construed with such modifications and so on. I mean, there wasn't anything saying that they were saved, as I recollect. I may be wrong. I don't remember.
No, Lord, I think I think your Lordship, if I may respectfully say so, is right. But but as I still submit that paragraph 24 is helpful to the board in terms of how the board should approach the scope of section 5. But I'm not going to repeat what I've said already. Lord, unless I can specifically assist your lordships, my lady, those were the matters that I sought to advance. Thank you.
Thank you very much. Mr. Knox?
My Lords, I have three arguments. The first is that the regulations in question are existing laws, and therefore they are saved from challenge by virtue of the joint effect of Section 18 of the 1976 Constitution Act and Section 6 of the Constitution. My second argument is, in any event, the regulations are not, on a proper and sensible construction, discriminatory. And thirdly, the regulations give only a power, not a duty, but a power that must be applied rationally and consistently with the Constitution. But there is no evidence that either Commission has applied or will apply these regulations irrationally or in a discriminatory way. This action, therefore, is academic, and there is no basis for saying that the appellant's rights are likely, that being the operative word, likely to be infringed within the meaning of Section 14 of the Constitution. My Lords, before I develop the legal arguments, can I just point out one or two matters of fact about how this claim came to be brought and the way there have been changes in the arguments. My Lords, you can see the original claims brought under the Constitution, under Section 14 of the Constitution, and the relief that was initially claimed is on page 2. Page 1 is the beginning of the motion, but page 2A and B. This is what the appellants initially sought in relation to both regulations. First of all, a declaration that Regulation 52 of the Police Service Regulations, Regulation 58 of the Authorities Commission regulations are null and void under Section 2 of the Constitution because they unfairly discriminate against women in contravention of Sections 4B and D of the Constitution. And then B, a declaration pursuant to Section 5 of the Constitution that the aforesaid regulations are to be construed as severed from the Police Service Commission regulations and or the Statutory Authorities Service Commission regulations on the ground they are inconsistent with Section 4 and a declaration that the aforesaid regulations cannot be used or relied upon by the Police Service Commission and so on as a basis for terminating appointment. And my lords, my lady, the evidence and support, my learned friend has drawn your attention to it, but can I just again remind you, it's on page 6, at paragraph 11. I'm now reading, I think, from the, still reading from the motion. What is said is that the regulations threaten the applicant's right to respect their private and family life, as it has discouraged them from marrying and or devoting time to their families, because they run the risk of termination. Unmarried women who care for their families do not run the risk of termination. Married women are in a discriminatory manner singled out by the regulations for this illegal ground of termination. And that in the premises, the regulations are void because they unfairly discriminate against women. So that's how it's initially put. My lords, our answer to that was initially on page 26. This is the respondent's skeleton argument. Paragraph 38. Essentially, paragraph 38 is a summary or conclusion of what has been said before. And essentially, what the state relies on is Matthews and the existing laws provision. That's its first response, and that's summarised in the end in paragraph 38. There's been a long explanation before then. And then paragraph 39, a second point is taken, which, my lords, I don't particularly take now, but namely, really, it's the commissions themselves who ought to be being sued here, not the Attorney General. In a sense, they have more of an interest in this matter. And then the third point, which is taken in paragraph, I think I'm right in saying paragraph 49, is the prematurity point. It's respectfully submitted that the applicants have no grounds bringing the action under section 14. The applicants must show the provisions of fundamental rights are either have been or are being or likely to be contravened. The provisions they are attacking apply to married women, neither of them is married, and neither of them has demonstrated any likelihood that the relevant commission is likely to apply to either of the provisions to them. Respondent would make this argument even if the applicants had demonstrated the regulations had been invoked against married women. And they've not even done that. There must be hundreds of married policewomen and hundreds of married women working for statutory authorities, yet the applicants have not revealed a single case where these sections have been invoked against them. My lords, in the Court of Appeal, there was a change of tack by the appellants, and you can see their skeleton argument begins at page 43, but the conclusion now, for which they argue, is summarised at page 68. Relief. If female officers are protected from future sex discrimination by reason of the declaration in section 4 of the Constitution, there will be no purpose in refusing a declaration that the discriminatory element in the regulations is eliminated by the removal of the word female in the expression female officer, or alternatively by declaring that the regulations do not apply to women alone. It would appear that conformity will be achieved if the word female is deleted from the regulations and the word his is substituted for her. Under the interpretation out, the masculine will include the feminine. So,
well, and vice versa. You don't need any substitution, do you?
No. Well, no. Anyway, my lady, the point is, initially there was a wholesale attack on the regulation, namely it should be got rid of altogether. And then in the Court of Appeal, what you've got is, oh no, the regulation is perfectly okay as long as you knock out the word female. Now, my lords, the state's answer to that, you can see, or the Attorney General's answer to that, page 73, in paragraph 9, and my lords, I draw your attention to this because it's said that a concession was made by the Attorney General in the Court of Appeal. My lords, my lady, my instructions are it was not. And you can see here what the Attorney General's position was. First, even if the applicants, I'm on 73, paragraph 9, even if the applicants were right and section 5 of the Act could be invoked in the interpretation of the regulations, there would be no question of those regulations infringing their constitutional rights. The law would be that on a proper interpretation of the regulations, those particular regulations either didn't exist or failed to be construed in accordance with the applicant's appellant's suggestions for their construction in their skeleton argument. If they were not construed in that way, that would be a matter for judicial review, just as the cases of Mollison, Rudall and Matthews were appeals in criminal matters rather than constitutional cases. The applicants have produced no evidence up to now to show that either of the regulations has ever been invoked against anyone, which is an indication that the commissions, the regulations are already being interpreted in the way they maintain they ought to be. And then over the page, secondly, 9.2, secondly, an applicant for constitutional relief under the Section 14 must show that the fundamental rights provisions are being or are likely to be infringed in relation to them. The regulations in question affect married women. The applicants are not married. It can be deduced that they're both middle-aged, one is divorced and has an adult son. Neither one of them identified someone to whom she was engaged to be married when she brought her matter in 2004, and no application has been made to produce new evidence about that. And again, they produced no evidence up to now to show that either of the regulations has been invoked against anyone. And the conclusion is then drawn. My Lords, I should make one point, a concession, in fact. I'm told that in the Court of Appeal, by my predecessor in the Court of Appeal, that he doesn't recall making any concession at all. But apparently the court recorded that the state had made a concession, but he doesn't recall making any concession, and it would be quite inconsistent with what you see there. The second point I should, however, make is that on the response to the petition, my predecessor in this matter did concede that the regulations were discriminatory. So, my Lords, my Lady, I should make that point plain. It was at that point conceded, but not in fact below. And in my
Mr. Guthrie, was it?
Yes, Mr. Guthrie. And in my submission, in my submission, it was a concession that perhaps should not have been made. My Lords, I say that by way of background, because I submit one has to look at this case realistically. And the most striking thing about it is that these regulations have been in place for 40 years, and it's not been suggested that they've ever been applied in an unfair discriminatory way. Can I first turn...
Why are they being maintained?
Yeah.
Well, my Lords, my Lady, one slightly gets the impression they just haven't been changed.
But here you are, defending them to the death in the Privy Council. I mean, why?
My Lord, I'm afraid I don't have any particular answer to that. It's not, of course, a matter for the Attorney-General. I mean, it's a matter for the relevant commissioners, and they are entirely autonomous. And so I don't think the Attorney-General couldn't just issue a diktat saying, look, chaps...
Suggesting he could.
Well, he might be able to suggest, but he certainly wouldn't be able to force.
Well, he could promote legislation which would alter their governing powers.
Well, my Lords, my Lady, one might think one of the points which has been made is that these regulations haven't been drawn, particularly, no one's really thought about these regulations very much until this action. And that's that, but simply because they haven't been used. And that might well be the real explanation.
All the more reason to repeal them.
Well,
this action's been going 5 years now.
I have no particular instructions on why they haven't been, but anyway, can I turn to my first argument?
Well, can we just, one further point on this, the suggestion that you simply excise the word female, thus removing the sex discrimination, but retaining the marital discrimination, which would be surprising to us in this country. But I notice that Section 4 of the Constitution only prohibits discrimination by reason of race, origin, colour, religion or sex.
Yes.
It doesn't contain the Article 14 other status provision.
No.
So perhaps it's all right in Trinidad and Tobago to discriminate against married people.
My Lady, I don't have any instructions to pursue that argument. It's not, if I may respectfully submit, on my argument, of course, I say none of this arises, but I take your Ladyship's point that one might construe the Constitution narrowly to say that because the words marriage aren't in the list of discriminatory matters, then it doesn't matter. But, my Lady, one can imagine there might be ways around that. Can I deal first with the existing laws argument? It's common ground, I think, that the police regulations were passed in 1966 under Section 102 of the old Constitution. and Section 102 of the old Constitution is at tab 1 of the bundle of authorities. And I think it's also common ground that the statutory authority regulations were passed in 1968 under Section 6 of that Act. And that Act was itself passed in 1966.
Could we just have a look at that?
The Act, or the Constitution?
Yes, the Act.
The Act is at tab 7, in volume 1. And it's Section 6, I think, of the statute itself. That's what the regulations themselves say there.
That's what the regulations say.
They, I think, say they claim to be passed under Section 6.
The Commission may, with the consent of the Prime Minister, by regulations or otherwise, regulate its own procedure. Yes.
Including the procedure for appointment and so on. And the exercise of disciplinary control.
We had this last week.
I see.
It's, I think there's somewhere else, another division.
Yes, my Lord, I think I went through. There's Section 28 too. Sorry, Section 28 as well, that is, where the President has a power to pass regulations.
But the board, the board has some power, I think.
And the regulations themselves claim, I think, when you look at page 356 in the same bundle,
I think it's actually the power to, is it not under the,
It looks as though Section 6 does authorise.
well, it may, including the procedure for appointment, promotion, transfer, removal from office, and so on. My submission, I don't think it's, anyway, I see the point that it might be said, well, these regulations are outside the powers granted by Section 6, and they might be within the powers granted by Section 28.
probably it is 6.
Sorry, Section 6 and Section 28.
And who is the President? Is it the President of the Commission or the President of the country?
I think it's of the country.
Yes,
Because you'll see Section 6, you've got to get the Prime Ministers here.
Yes.
Yes, it is.
And I'm not sure it's defined, if he's defined, in fact, in the definition section at the beginning.
But the grounds for termination of employment would appear to fall more naturally under Section 28 than under Section 6.
Well, because they express the sensitive, something within his power. But on the other hand, one can see there's an overlap. The procedure for appointment, when you look at Section 6, or rather Regulation 6, my lady, one doesn't have to read the two regulations as mutually exclusive. I see, of course, I see the point. But in my submission, Regulation 6 is wide enough. My lady, I'm at some disadvantage in one sense because it may be that this point's been considered earlier, but of course it is a new point. And when I was reading the regulations yesterday, I was slightly puzzled at the fact you've got two powers, and the latter power might be more appropriate for the bringing into effect of certainly some of these regulations. But the former power, my submission, is wide enough in any event.
Well, the President's power is dealing with much more substantial matters, by and large, isn't it? And substance, and Section 6 is dealing with procedure.
Well,
as a broad brush
yes,
way of looking at it.
If you put, yes, my lady, it depends how much emphasis you put on the word procedure. And quite how and construe. I don't think the word procedure is defined. But, my lady, I don't think I can advance the matter much further and say that apparently, unless, my lady, there's some mistake. I mean, what does happen sometimes that you see are made under Section 6, and in fact you find it may have been made under some other power. But leave that on one side.
Well,
I can't at the moment say they were made under Section 28.
well, it would depend upon who made them, because it's two different people making them.
Well, it doesn't say who made them, I don't think. That, no doubt, is taken for granted. I'm just looking to the end.
It's funny, 'cause some of the other regulations say under which section they're made.
Oh, the Statutory
Section
Authorities
6.
Service Commissions say they are made under Section 6.
6, so that's it. Section 6.
Yeah.
There must
Page 356.
Yes.
There must be a question.
So, I don't think I can advance the point much further. I mean, that is what they say they've been passed under. The point hasn't been taken so far that they're all entirely ultra vires because they should have been made by the President. Now, I suppose there might be a difference. The President, of course, would normally have to act on advice given to him. But on the other hand, the Prime Minister has to approve these regulations. But, my lady, I think for the moment I submit that they come within the power, within the statutory power that's been granted. My Lord, it's clear that no challenge was made to the regulations by the appointed day, which was the 1st of August 1976. In other words, that's the day when the new constitution came into effect. And again, turning to the police regulations, again, they were passed under Section 102. Perhaps given the point which is just the reason I should go back to Section 102 of the old Constitution. Because, my lady, I think you can see how Section 6 was used the way it was when you see how Section 102 was drafted and what happened under Section 102. Because I think...
What page is it on?
This is on page 82 in the first bundle. Just sort of drawing together the chronology. This, of course, is 1962. The police regulations are passed first, directly under Section 102. Section 102.1.
I think I've got a problem with the pages here. Again.
Page 82, yes.
Yes, mine have been bound up in a different order. Thank you. Found them.
Subject to the provisions of subsection 3 of this section, a commission to which this section applies may, with the consent of the Prime Minister, by regulation or otherwise, regulate its own procedure, including the procedure for the consultation of persons with whom it is required by this Constitution to consult, and confer powers and impose duties on any public officer or on any authority of the Government of Trinidad and Tobago for the purpose of the discharge of its functions. Now, this is the regulation under which the police regulations are made. Sorry? I know, I'll come to that in a minute. And then, my lords and my lady, you'll see that these words, in fact, I think are not entirely dissimilar to the words in Section 6 of the Statutory Authorities regulations. No doubt, one can see, as it were, the train of thinking must be, well, you've got the Police Commission regulations passed under Section 102, and then you've got a similar form of words in Section 6 in the Authorities regulations. So, ergo, you must be able to do the same type of thing in 1968 with the Statutory Authorities regulations as was done in 1966 with the police regulations. That appears to be the sequence and the line of thinking. If you going back to Section 102 of the Constitution, you'll see subsection 5 in section 102 on page 83, references in this section to a commission to which this section applies are references to the Judicial and Legal Service Commission, the Public Service Commission, the Teaching Service Commission, or the Police Service Commission, as the case may be. So that's that. And then you have you have some definitions in section 105 at the foot of 83. In this constitution, unless otherwise provided or required by the context, then you have various definitions. The relevant ones would be public office, and then public officer, and the public service. I don't propose to read those out, but that, I think, is how you add up the various provisions. To get to the relevant powers. My lords, my lady, can I first of all deal with the police regulations and ask, were they an enactment under section 18 of the 1976 Constitution Act? And in my submission, the answer is they plainly were. The former Constitution, if one goes to the former Constitution and turns to section 38, and this is, I think, at tab 1, section 38. Page 41. And now in the 1962 Constitution, and section 36 is the provision that gives Parliament powers to make laws for the peace, order and good government of Trinidad and Tobago. And then section 38, you have the power under the old Constitution to alter any provisions of the 1962 Constitution. And then you turn to the 1976 Act in tab 3, and you can see from the beginning of this Act that it is passed specifically pursuant to section 38(2) of the old Constitution in order to bring in the new Constitution. You can see the intention declared at the end. And my lords, I just mentioned these points by way of background because in my submission it is important to see what the purpose of section 18 is. And it's my submission that the purpose is quite clearly, so to speak, to provide that we no longer have to look at the old Constitution. Let's just start off with the new Constitution, and if something has not been declared unlawful yet, then that's that. You just start off again with a clean slate, so to speak, with the new Constitution, even though some laws passed under the old Constitution might have been unconstitutional.
Slightly dirty slate, perhaps.
Well,
Yes.
my lords, my lady, one can understand, but there is a point. It's not as stupid as all that. When one's looking at simplicity, there is something to be said for constitutional simplicity. And it is rather an unsatisfactory position on the face of it, that what one will be doing when you've got a new constitution is having challenges, so to speak, which were brought under the old constitution. And one can see the sense in saying, look, let's just start off all over again. We've got this new constitution. If it was there before the new constitution, that's that. And that, in my submission, is the purpose of it.
It seems that is one way of looking at it, and I'm sure that you're right that that's what the purpose was, but it seems an odd thing to do, to put people in a worse position than they would have been if the 1976 Constitution had never been passed.
My lady, that's why I drew your attention to section 38 of the old Constitution and just how this Act itself came to be brought. In other words, it is brought with a majority, it's a requisite, it's not just a normal statute, it's brought with the requisite majority to bring in the new Constitution. That's the point. Can I turn to the words themselves, in section 18? Dealing first of all with the police regulations, there are three things in my submission I have to show. First of all, that this is, or that they constitute an enactment. Secondly, that it's been passed by an authority or a person. And thirdly, that it's been passed either under or by virtue of the Constitution.
Passed or made.
passed or made, by virtue or under. The first point is enactment. And in my submission, enactment must cover regulations because it's envisaged that the enactment can be passed not just by Parliament, but by a personal authority. And obviously no one has power to pass, it must therefore cover regulations. Second question, well, is the Police Service Commission an authority? I submit obviously yes. Authority I don't think is defined, but it must be an authority. And then the next question is, well, were the regulations passed under or by virtue of the former constitution? And in my submission they were, I think they could be said directly to have been passed by virtue of the former constitution, or certainly under it, because they were actually expressly passed under a specific power of the former constitution. And in my submission that really is it in relation to the Police Service Commission regulations. They are plainly preserved by section 18. One then turns to section 19 of the same Act, because of course it might be thought that if the old constitution is going, then all regulations passed under the old constitution go as well. But section 19 preserves those regulations and treats them as being continued under the new constitution. All enactments passed or made by any parliament or personal authority in pursuance of the former constitution for the purpose of prescribing any manner or thing authorised or required to be prescribed by the former constitution is correspondingly authorised or required to be prescribed for the purpose of the constitution shall, until some other matter or thing is prescribed in pursuance of the constitution for the purpose thereof, continue in full force, and so on. And then one turns to section, I think it's 136 of this new constitution. No, I do apologise, I think I've given you a bad reference. I think it's section begins at section 120. It's page 96 at the top. It's section 122.
Is this about the Police Service Commission?
Yes, about the Police Service Commission. I think it's section 129.1. Subject to subsection 3, a service commission may, with the consent of the Prime Minister, by regulation or otherwise, you have the same form of words as you had in the previous equivalent constitutional provision.
Yes?
So, my Lords, in my submission, the police regulations are plainly an existing law within section 18 of the 1976 Act, and therefore they continued in force, and notwithstanding any possible inconsistency with the former rights declared in the former constitution. The next question, my Lords, one then turns to section 6 of the 1976 Constitution, tab 3. Which you've already seen, but may I take you through it again? Page 20, section 6, and tab 4, tab 4. Nothing in sections 4 and 5 shall invalidate an existing law. So, my Lords, I submit it is simple. The police regulations are plainly an existing law by virtue of section 18 of the Act, and then nothing in sections 4 and 5 shall invalidate that existing law. Now, of course, the issue was raised in Matthews quite what is the effect of section 6, but in my submission it is clear from Matthews paragraphs 13 and 14 that the effect of section 6 is that existing laws are part of the Constitution, and the Constitution itself preserves the existing laws. Therefore, you cannot go outside the Constitution to the Act itself and say, oh, well, you can modify them for inconsistency with the Constitution, because they are not inconsistent with the Constitution, because they are saved by section 6. My Lords, that is the decision in Matthew, and in my submission that cannot now be gone behind in this case. My Lords, the relevant paragraphs where that point is made in Matthews, this is quite independent of the scope of Section 5 of the 1976 Act. There's nothing to do with it. Is paragraphs 13 and 14 of Matthews, or Matthew. Tab, I think it's 13. It begins at paragraph, the passage begins at paragraph 13 and finishes at paragraph 17. The question in this case, however, and this really is exactly the same argument as Sir Fenton and Mr. Newman raised, the question in this case, however, is whether inconsistency with sections 4 and 5 has any effect on the validity of the mandatory death penalty. Section 6.1 contains an exception to the operation of the previous two sections. It's page 694 at the foot, and then section 6 is recited, and then reference is made to the Offence Against the Person Act in 1925, which contained the mandatory death penalty. Mr. Fitzgerald's submission, paragraph 15, is that a power or duty to modify section 4 of the old Offences Against the Person Act can be derived from section 5.1 of the 1976 Act. Then that is recited, subject to the provisions of this section, the operation of the existing law on or apart from the appointed day shall not be affected by the revocation of the order, but the existing law shall be construed with such modifications, adaptations, and so on, as may be necessary to bring them into conformity with this Act. He submits that section 6.1 does not mean that sections 4 and 5 have no application to an existing law. It says only that those sections shall not invalidate such a law. This is by contrast with section 3.1 of the previous constitution, which said that the equivalent sections should not apply in relation to an existing law. Mr. Fitzgerald described that section as a shut-out clause, which precluded any judicial examination of whether an existing law was in conformity with the sections declaring human rights and fundamental freedoms. But the fact that sections 4 and 5 cannot invalidate an existing law does not mean that the law is deemed to be in conformity with them. The Court is still obliged by section 5.1 of the 1976 Act to modify the existing law to bring it into conformity with sections 4 and 5. The only thing it cannot do is wholly to invalidate such a law. Their lordships reject this submission for much the same reasons as they rejected a similar submission in Boyce and the Queen. It is inconsistent with the supremacy of the constitutional irrational consequences and contrary to the language and purpose of section 5.1 of the 1976, I think must be, Act. And in my submission, that is a short answer to it. Now, my lords, my ladies, the question has been raised as the precise scope of section 5.1. Now, it's helpful to go, I think, to a paragraph in Boyce which you weren't taken to at tab 12. I think we're taken to paragraph 48. Sorry, paragraph 49, but not paragraph 48. And my lords, I shall explain this in a moment. I may in a little more detail. My lords, I have this at page, it's at tab 12, and I have this at page 657, although my pages go backwards for some reason. Paragraph 48. The objection to Mr. Starmer's construction, and this is exactly the same as Mr. Fitzgerald's argument in the Matthew case, is not to the breadth of the power for modification, but to the circumstances in which he submits that the power may be used. The power may be as broad as one pleases, but its obvious purpose is to save existing laws from being declared wholly void, not to allow the courts to modify laws which would otherwise be valid. And that's the important part of the sentence, not to allow the courts to modify laws which would otherwise be valid. As Lord Hobhouse said in Brown and the Queen, of a statutory proviso inconsistent with the Constitution, it is the duty of the court to decide what modifications require to be made to the offending provision in the proviso and to give effect to its modified form, not to strike down the proviso altogether. And then the paragraph 49, which I think you've seen, thus the purpose of section 4.1, which is the equivalent of 5.1 in the Trinidadian Constitution Act, is to ensure that so far as possible substance will prevail over form. Courts are empowered and encouraged not to reject provisions to which there can be no substantive objection, merely because as a matter of language and form they are bound up with provisions inconsistent with the Constitution. Instead, there's a broad power to remould language and form to sever the good from the bad. It's obviously unnecessary to discuss the extent of the power. It obviously has substantive limits. For example, when it presents the court with choices which are more appropriately made by the legislature. But whatever the breadth of the power, it is truly incidental or supplementary to the Constitution because it is ancillary to the supremacy of the Constitution over other law. Its purpose is to enable the courts to preserve the effect of existing laws so far as possible.
Well, I have terrible trouble with this. I'm finding it extremely difficult to work out exactly what it is that is being said can and cannot be done. I understand what was being the actual ratio of the case, of course, but if one goes on to the example in paragraph 50,
yes,
this is talking about excising one of the prescribed punishments from the Burglary Act. This is an imaginary example, as I understand it.
Yes.
On the grounds that it is cruel and unusual or whatever. Anyway, certainly contrary to the Constitution. That's the example. That refers back to the example in paragraph 40.
yes.
And all this language about severing the good from the bad and talk about the offending provision, this all seems to be being used in the context of something which offends against the fundamental provisions of the Constitution. Can't mean anything else. So what is it getting at? If one reads these paragraphs...
Can I explain? The important thing is section 20... I agree. If you look at paragraph 40, you have the example of a burglary act passed in 1964. Now, I have a feeling that the Barbadian Constitution came into effect in 1966. So what's being posited here is that the law passed shortly before the Barbadian Constitution came into force, and therefore is an existing law. I think I'm right in saying it's 1966 is the relevant date. You then turn to paragraph 50. Thus, in the burglary example mentioned earlier, if there had been no section 26. Now, section 26 is the existing laws provision in Barbados. The 1962 Act would have been declared void. Now, the point that is being made in my submission is this. The power of modification can be quite wide, but, and one can imagine certain circumstances in which you might need it. For instance, supposing the inconsistency that you're attacking in the Constitution is not with the fundamental rights and freedoms in Chapter 2, I think it's Chapter 1 or 2, but with some provision, let's say in Chapter 7. There's an inconsistency with a totally different provision. Now, there would be no existing laws clause that would save the inconsistency with the provision in Chapter 7. That's the point. And you can then modify the provisions and you can then modify that law. In other words, what you can't do is use the modification provision to modify a law which is expressly saved as an existing law on the basis that it's not on the basis that it might be subject to attack for inconsistency with sections 4 and 5.
But does this actually... I mean, this example doesn't fit there, does it?
Well, I think what Lord Hoffman is saying here is, look, supposing there had been no existing laws clause in Barbados, supposing you hadn't got that clause at all, but you did have the modification provision, what you would then be able to do with this offensive burglary act is say, look, this is a jolly bad act, we can use the modification provision to get rid of the flogging bit. That's
in fact, Lord Hoffman's example is quite complicated. We have to read section 30, paragraph 39 as well as paragraph 40 to make sense of it. And it does need a bit of unpicking, I think.
I'm grateful.
The whole of the example in paragraph 50, you're saying, is governed by the words, if there had been no section 26.
Yes.
I mean, it was to deal with, I mean, what Lord Hoffman was saying was that Mr. Starmer had put a limit in order to, because he had to explain how if he was right and this clause could be used to modify things, nonetheless, there was the existing laws clause, and he said the two worked together. And he therefore said you could not, there was a limit to what you could do under the modifying power. And what Lord Hoffman was dealing with was showing, and one gets it in 39 and 40, that the limit which he put on it was irrational.
Yes.
And he therefore said that if, on the contrary, if Section 26 hadn't existed, one would have been able to do whatever was necessary, whatever the form of legislation. That was the point. I mean, it is difficult to just pick out individual paragraphs, but that was the argument.
I'm sorry, I should have taken it back. I myself hadn't, as we've gone back to 39, I'd started at 40. But I think that's the answer. In other words, the power could be, in principle, can be quite a broad power. The trouble is, it can't be applied to change a law which is expressly saved as an existing law. That's the short point. And so once, as it were, and this is why it's important, for the purpose of my argument, to establish that these enactments are, properly speaking, existing laws, whose validity was preserved. Once I get into that, as it were, box, then I submit Matthew, well, Section 6 applies, and Matthew is binding.
And paragraphs 22 and 23?
Are simply dealing, I think, with...
of Matthew, I mean.
But yes, in Matthew. I was just about to come to them.
Sorry.
No, I was literally about to come to them. On 696.
You get the context from the first sentence of 21.
Yes.
The irrational consequences of construction from which Mr. Fitzgerald contends, namely, that any law incapable of modification or addition remains valid, are fully discussed.
Yes.
That was
And that's the context in which what is said in paragraphs 22 and 23 is said. In other words, it is quite a broad power, but it can't be used to attack an existing law. But if the law, for some reason, is not an existing law, well, Section 5, you can certainly do what you like. My lady, can I put the point simply for the purpose of this
Still having trouble with paragraphs 22 and 23.
Can I just put it in this simple dichotomy? If the police regulations are not an existing law within Section 18 of the 1976 Act, suppose for some reason they're not an enactment or they're not passed by an authority, then I fully accept that they are not saved as existing laws within Section 6 of the Constitution, and then I fully accept that you come along with Section 5 of the 1976 Act and modify it. And I accept that. I don't think... there wouldn't be any great objection to that. Apart from anything else, you'd have to do something to the law because it would be inconsistent with the Constitution.
Whereas the import, at least the way it seemed, of Mr. Starmer's argument was that if you had had an isolated, supposing there had been an isolated act or provision which had contained what is in 52, whatever it is, then in that situation you couldn't do anything about it because you couldn't, the power didn't extend to removing something altogether. It only led to modifying. That's why Lord Hoffman says that led to the situation that if it was in a consolidation act, you could remove something, but if it was in a single act by itself, you couldn't. I mean, it was that was the kind of that was the argument he was dealing with.
It's all slightly topsy-turvy. I think that was the problem. And one might think that Mr. Starmer was arguing for a wide power modification. In fact, he was arguing for a sort of slightly artificially circumscribed power modification. And that's the paradox, which one won't immediately get just from reading parts of the judgments. So, my lady, I hope you have, as it were, my submission, that really what matters is not the power of modification, but the fact that a law is an existing law or not. And if it is, that's an end of it. The power of modification doesn't come into it. If it isn't an existing law, you can modify it to get consistency. And that in my submission is also the answer to my learned friend's reliance on the Rocas case, the Gibraltar case, about the jurors. Because in that case, there was no existing laws provision. And so you could use the modification power, the equivalent modification power in the statute, to modify the law for inconsistency with the Gibraltar Constitution. So it all turns on the presence or absence of an existing laws clause in the Constitution itself. In my submission, the same arguments apply. I've dealt so far with the police service regulations, The same arguments apply to the statutory authorities regulations. There is, of course, one difference, namely that those regulations are not, as we've seen, passed directly under the Constitution. So the question then is, which I have to, as with a hurdle I have to get over, is going back to the words of the Act, the 1976 Act in tab 3, in section 18, page 109, all enactments passed, well, again I say it's obviously an enactment, passed or made by any parliament or person or authority. And again I say, well, clearly it's a person or authority who has made these regulations, and then under or by virtue of the former constitution. Now, I imagine the point that's taken against me is, well, these aren't passed under or by virtue of the former constitution. They're passed, so to speak, by, they're passed pursuant to a statute. To which my answer is, well, no, but that statute itself was made pursuant to the old Section 38 of the old Constitution. It was made Section 36 of the old Constitution, Parliament's powers of making laws for the peace, good order and governance of the country. So in my submission, one can properly say that the regulations, as they were passed under a statute that itself was passed under the former Constitution, constitute regulations that are passed under the former Constitution, or at least by virtue of the former Constitution. And in my submission, I come back to what I say is the evident purpose of these regulations, namely whether one uses dirty slate or not, is to provide simplicity. And it's difficult to see what rational scheme there would be for saying, well, statutes are saved from challenge, but regulations aren't. And in my submission, that is difficult to see what the purpose of that would be, and one would imagine if that was to be the purpose of the draftsman, he would have made that plain. Otherwise, these words, which are in very general terms, are apt to be misleading. My lords, you were taken to the case of Suba, which all turned on the question, which was a case which essentially turned on the point, well, what is the executive of possibly the prerogative power in granting medals, is that an enactment? Well, clearly that issue is a completely different issue from the one you've got in this case. So that case doesn't help me very much. So what I say about the statutory authority regulations is exactly the same as the police service regulations. They're an existing law. And that, I'm afraid, my lords and my lady, is an end of it. That's my first argument.
Well, would that be a point to stop? Yes. Shall we resume at 2 o'clock?